Hello, this is Professor Bustillo-Booth, and welcome to a learning session with employment law. Let's go ahead and get started. For this session, we will focus in on the historical perspective of Title VII of the Civil Rights Act of 1964, as well as discuss affirmative action and the federal and state agencies responsible for administering and enforcing the laws. In 1619, the first slave ships arrived to America. And it took about 246 years for slavery to end as a result of the end of the Civil War and the passage of the 13th Amendment that abolished slavery. And it took nearly 100 years later for the Civil Rights Act of 1964 to pass, which basically ended segregation in public places and made employment discrimination illegal on the basis of race, color, religion, sex, and national origin. And it was the crowning glory of the civil rights movement. It is important to note that about a year later, in 1965, the Voting Rights Act passed and signed into law by President Johnson. What it did was to remove what was then the legal barriers at the state and local levels that prevented African Americans from exercising their right to vote, which was already guaranteed by the 15th Amendment to the U.S. Constitution, but made difficult to exercise because of polling taxes and literacy tests. So the Voting Rights Act of 1965 basically removed those barriers and made them illegal. From a historical perspective, it's important to consider the length of legal racism, beginning with 1619, when the first slave ships to America arrived, and to 1965, when the Voting Rights Act passed, and that this time was nearly 3.5 centuries. And that if we were to look at 2018, illegal discrimination has only been for about 52 years. To fully appreciate the drive behind the civil rights movement and the passage of the Civil Rights Act of 1964, especially today when for some discrimination may seem like a distant past and perhaps certain laws may no longer have relevance, it's good to take pause and take a look at recent history, right? And so this was around the 1950s, this ad here, where it illustrates that certain institution kept alive and perpetuated racism as a societal approach. And so you'll see here in this ad, there were categorizations of male employment and female employment, presumably in that first column of white folks, and then the employment of colored folks on the other. And this is the institution of employment. In this particular image, it illustrates the institution not only of transportation, but just how people kind of moved around in society, where folks were segregated in terms of where they could wait for transportation, or also in hospitals, or where they could even have their water. And then here you could see a sign that says we cater to white trade only, and this is the institution of business, and that where folks were segregated to what kinds of business activities they had access to, and their participation in the marketplace were severely limited. And of course, there were other institutions like education and housing, where folks were relegated to substandard educational quality or access to funding or housing. And so there was a whole societal approach to who had rights and certain privileges and who did not. And these rights and privileges were supported and enforced by the rule of law. The only way to eliminate that societal approach over time was the passage of a new set of laws that had different value systems underpinning it. So the idea of equality for all. And that's what happened in 1964 with the passage of the Civil Rights Act. In our study, we will focus in on Title VII, which made it illegal to discriminate against someone on the basis of race, color, religion, national origin, or sex in the area of employment. You could imagine that the passage of the Civil Rights Act was hotly debated, greatly resisted by certain camps, and that it took a congressional act to have it pass. Now, presidents have other powers to advance their own particular agenda without Congress, and that's through executive orders. And in this case, Kennedy signed Executive Order 10925 in 1961, where it basically said that it was illegal for contractors to discriminate against any employee or applicant for employment because of race, creed, color, or national origin, and that it required them to take affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, creed, color, or national origin. And that, these actions could include, but were not limited to, around employment, promotions, demotions, or transfers, recruitment, and or recruitment advertisings, layoffs, or terminations. So it covered a gamut of employment conditions, and this was passed in 1961 and in many ways informed ultimately what was written in Title VII. And Johnson reaffirmed it and did some updates on it in 1965 and 1967. To be clear, the executive orders were for federal contractors with a certain amount of funding from the federal government, and they had to have these mandatory action, affirmative action plans in place, and they had parameters they had to meet, and they were enforcing agents to make sure that occurred. Now, in the private sector, private employers were encouraged to have affirmative action plans. They were not required. They were encouraged to have these voluntarily in place so that they could start promoting equal opportunity and avoid litigation. And the idea there was just because the law was put in place does not mean that people were all of a sudden going to stop discriminatory practices, and that there were a lot of things that had to be mitigated, and certain practices would have to stop. And so affirmative action in that sense was to promote equal opportunity. As a result of these laws that had differing languages, there was a great amount of confusion. And on the one hand, Title VII said basically, thou shalt not discriminate based on race, color, national origin, and sex. On the other hand, there was affirmative action, the executive orders that basically said, thou shalt create equal opportunity. And there were folks who interpreted that as reverse discrimination because it would, one seemed neutral, thou shalt not discriminate on, on any of these particular traits. But on the other hand, let's advance those who are particular traits. And so Congress then had to go back and say, no, that's not what we meant. Let's harmonize the intent among all these laws around Title VII, which is to make discriminatory practices illegal, and the executive orders that says let's promote equal opportunity and equality, and the other laws that basically kind of were in tandem at that time. And they basically said, what we want to do is to identify when affirmative actions would be allowed. All right, and one of these would be the idea where there were adverse effects. And in another chapter, we talked about what that meant. This is synonymous to the idea of adverse impact, where there are policies and procedures and practices that seem neutral on, on the surface, but really impacted certain groups disproportionately and negatively so. And another instance would be addressing the effects of prior discriminatory practices. So if you were looking at your labor pool and it had one segment of the workforce, and then there was a study that showed, in the larger workforce, the set of qualified individuals were really more diverse than your own particular workforce has currently, then you could put affirmative action plans in place to correct that. And then if there were an instance where you had, employers had a limited labor pool, affirmative action plans could also be put in place to expand that labor pool to have a representation of qualified applicants from diverse populations. So it wasn't just going to have a pool of qualified applicants from one group, but a pool of qualified applicants from a diverse body of applicants in this case. And so there were, and here are some affirmative action steps that could be taken that were allowed. So a company, for example, can have training plans and programs like on-the-job training, which would emphasize really providing historically disenfranchised groups with opportunities to increase their skill sets and have experiences they would need in order to, perform certain functions and have access to those jobs, right? And then you could also, it would also be allowed to have extensive and focused recruiting activities in areas where the company might have historically not tapped, and where women would tend to be, or other historically disenfranchised group would tend to be. Basically, the plan would be allowed to expand its reach beyond kind of where it had been comfortable, and doing its own practices. So, for example, if the main way a company had been recruiting is through word of mouth, and we know that recruitment through word of mouth would tend to attract those people who are like you, that would result in a limited labor pool. And so an extensive and focused alternative recruiting procedure would be to have advertisements that are not just word of mouth, but it would be have a much wider reach, so that it could tap a bunch of qualified people across segments of the workforce population. And then another uh, step that one could take is to eliminate adverse impact through selection criteria that did not really line up to how and affect how somebody could do their job. It wasn't really relevant to their ability to carry out the job. And then there could also be modifications around collective bargaining. We will talk more about labor law much later in the course, but there was historically also segregation within unions and labor organizations. And so in order to correct those practices, affirmative actions could be pursued in order to create equal opportunity. To be clear, the establishment of voluntary affirmative action plans is not an open-ended session. There are strict guidelines that are set by enforcement agencies and upheld by the courts, and in some ways also set by the courts, in order to protect employers from reverse discrimination claims. There are at least three elements that must be present in order to institute an affirmative action plan or program. One of which is to do a reasonable self-analysis. While there is no mandatory method required to conduct the analysis, it is generally understood that this be based on verifiable data. So there'll be evidence of wrongs that need to be corrected. And so the objective of the self-analysis is to, quote, determine whether employment practices do or tend to exclude, disadvantage, restrict, or result in adverse impact or disparate treatment of previously excluded or restricted groups, or leave uncorrected the effects of prior discrimination, and if so, to attempt to determine why. The second condition that must be met is that there must be a reasonable basis to show that one or more of the employment practices did tend to adversely impact employment opportunities of members of the previously excluded groups, and or leave uncorrected the effects of prior discrimination that then or it resulted in disparate treatment. These things, the action plans themselves would have to have a basis for action. And the third then is the reasonable action itself. And I quote here, that's written in the guidance, quote, the action taken pursuant to an affirmative action plan or program must be reasonable in relation to the problems disclosed by the self-analysis, and that those reasonable action may include goals and timetables or other appropriate employment tools. A case in point on how the harmonization among Title VII, affirmative action plans, and other laws around its intent to promote equal opportunity and basically eliminate discrimination is in a scenario that was discussed in your book. So for example, in that case, a union had not permitted African American members to be part of its ranks because its white union members had resisted it. and then that Black employees sued and won, and the court then ordered certain remedies, but the union continued to resist having African Americans as members. And eventually the court said, well, we are now requiring you to admit a certain number of African Americans by a certain time or be held in contempt of court. Now that is allowed and permissible under Title VII because, that the analysis had already been conducted in this case. There were already a reasonable basis that was established, and that there was already adverse effect. And if uncorrected, effects of prior discrimination would continue to persist and result in disparate impact and disparate treatment. And that the reasonable action to take then is to have a goal, or some people would say what a quota on timetables. And in this case, it was a limited period of time so that those numbers could be reached, and then correct the effects of prior discrimination, particularly because it persisted for so long. Similarly, in another scenario where an employer was found to have discriminated and ordered as an appropriate remedy to promote one female for every male that is promoted until a desired goal is met, that is also permitted in the court, and the employer is then protected from reverse discrimination. And the intent there again is to correct the effects of prior discrimination, and also to have a quota system for a limited amount of time until they've established a balance of opportunity. The precedents for allowing this kind of protection on employers against reverse discrimination was really established in a series of laws or court decisions, in particular what's called the Weber case. And the long title of that is United Steelworkers of America, AFL-CIO versus Weber. And in that, the court held that race-conscious, voluntary race-conscious affirmative action plans were permitted, and to eliminate racial imbalance that had persisted for so long, as long as the measure is temporary and it did not unnecessarily trample on the rights of white employees. There is, of course, an ongoing debate on whether or not affirmative action is still relevant today, and why or why not. In our data-driven and evidence-based world, we can actually track quite a bit of where certain groups tend to be populated with respect to employment opportunities. Here are some data that was produced by the EEO, the Equal Employment Opportunity Commission. And this is in 2014, the numbers of the latest data in 2015 are not that much different. And what I want you to take a look at is in the y-axis would be the percentage of the population, and then on the x-axis would be the kinds of positions that are held, right? These are general categories from executives all the way to the service employment. And there is a correlation here in terms of income, which tends to be that of course, executives would earn more than, say, the laborers or service sectors. And you can see here that magenta would be the white population, the green would be all employees, and then the orange line would be of minority groups, and they're shown here. And what you'll see is that in the upper echelons of the economic ladder, there's a great divide between white employees and minorities, right? So from 23% to 15%. And then if you were then to look at the other end, there is a reversal, and that is where, as on the upper echelons of the economic ladder, we have the white employees occupying those positions. We now have a reversal on the other end in the labor and service sectors, where it is the minority population that tend to occupy higher percentages of those jobs. We'll take a look at this data set with further disaggregation of Black employees and Hispanic employees. So if you take a look at this end here, while we see professionals, we have white employees occupying about 24% of those professions, of those positions, and Black employees about 11%, which is about a 13 percentage point gap difference. And interestingly, the Hispanic group has even a larger gap. If we look at the other end, you will see that it has reversed in terms of who's on top and who's at, occupying less of those positions. We have the Black employees have about a 26% representation in the service positions that tend to pay less, and also the white employees have 12% of the same positions, and that is over a 14 percentage point difference. Particularly interesting is to take a look at this data set across states. And so what you're looking at here are job patterns for minorities in the private industry in Washington state. And you can see that the gaps are still present, but not nearly as wide as when we saw it at the national level. And so here you'll see the minority population in orange, and again the white employees in magenta. And you'll see that there is in the professions area positions, there is a much lesser gap. I mean, the gap exists, but it's much less. But that role reversal is still continues at the other end. Now, here is the one in Georgia. You can see that in the profession positions, there is a much wider gap in Georgia than there is in Washington state. And this is, nearly an 11-point percentage difference. And then there is also, again, that reversal that occurs at the end. And then here's Alabama, and you'll see that, again, that gap is large. And then it again reverses on the other end of the positions that we've been looking at. We are back to the data set that we started with, and in considering this data set along with other data sets at the state level that shows great variances, where opportunity gaps still persist, and arguably because of that great societal approach that are still within our institutions, and where the rule of law really has stepped in to basically eliminate some of those practices or make those practices illegal that keep people from accessing the positions where they are otherwise qualified. It's going to take some time to eliminate gaps like this, right? And it will take a concerted effort by employers to open up their doors to reach out to a wider breadth of qualified applicants. The administration and enforcement of the rule of law around anti-discriminatory practices really rests on the Equal Employment Opportunity Commission, or the EEOC for short. And there are definitions in the law as to who the employer is, and that would be covered under the law. And these are employers in the public and private sectors who are engaged in industry affecting commerce, so this trade, who has at least 15 or more employees. And there are those who are not included in the definition of employer under these laws. And the United States government, for example, Indian tribes, and the Department or agency of the District of Columbia. They are covered by other laws, just not by Title VII. And who is not covered are, interestingly, and it's important to kind of keep in mind, because when we go into employment claims, you'll have to ask yourself whether the law actually covers those claims. And so employees of employers with less than 15 employees, not covered. And employees who are not engaged in interstate commerce, not covered. Non-U.S. citizens employed outside of the United States, employees of religious institutions, members of the Communist Party, and employers employing Native Americans living in or around Native American reservations. Now, there are other laws and different parameters involving these groups, but they're not covered by the Title VII and other federal laws around anti-discriminatory practices. Now, the timelines for the EEOC are important to keep in mind. So a charge must be filed with the EEOC within 180 days from the date of the alleged violation in order to be protected, to protect the charging party's rights. Now, there is also the Lilly-Ledbetter Act that allows for kind of a resetting of each alleged violation, and we'll talk about that later. But the timeliness, however, is 180 days from each, from the date of the alleged violation, and that 180-day filing deadline is extended to 300 days if the charge is also covered by a state or local anti-discrimination law. Now, it's important to understand that an applicant who has a claim cannot just jump to court, that there is a process set up by the system to exhaust all administrative steps and the EEOC or its equivalent agent at the state level before a claimant can go to court. So in this case, if you look at the graphic here, is that an applicant or employee files a charge to the EEOC, and then if you look at this decision tree, the EEOC will then see if a mediation is an option, and if it were successful, and if not, then it goes through a different set of steps, right? And so there is a process that must first be exhausted before a claimant can go to court. At the state level, we have the Washington State Human Rights Commission as the counterpart for the state federal enforcing agency of the EEOC. And note that the Washington State Human Rights Commission was established in 1949, well before the passage of the Civil Rights Act of 1964. And what this really should bring to mind is that there are states who are at the vanguard of the civil rights movement, and we had established our own anti-discriminatory practices. And this is actually pretty historically normal, in the sense that states will lead movements and then they percolate up to the federal level, and then the law then applies to all of the 50 states and its territories. And it may explain why Washington State has a narrower gap of the disparities between groups, whereas other states who did not adapt the federal laws until much later would suggest. So in our case, we've had this law for some time, and in fact have expanded it to protect more than what the federal law actually allows. And so you'll see here, there's quite an expansive list. In addition to what the federal government already includes, we have added things like sexual orientation, honorably discharged veterans or military status, the use of a trained dog guide or service animal, HIV/AIDS, and hepatitis C status, and so on. And so our laws actually go beyond what the federal law allows for protections. And our jurisdictional criteria is also much higher bar. So whereas the federal government will say 15 employees, we're actually saying at least 8 employees. And it does not include religious organization in this case, and that signed complaints need to be filed within 6 months of the last date of alleged discrimination, which is similar in harmony with the EEOC. Okay, so I just want to close out our session by noting some of the references that were used for our discussion. And of course, there are others that I invite you to take a look at. So if you want to take a note at which ones were used today, please go ahead and pause your video to write them down. And be sure to cite your references when you do your work. That brings us to the end of our learning session. As you can see, employment law is a highly technical matter, and I invite you to read your required text very carefully and to go over the cases so that you get a sense of how the court thinks about how to address discriminatory practices and the remedies that they seek, and sort of the underlying basis for their decisions. Now, for my students who would like to have further guidance with me, please reach out to me through my contact information, which is detailed in the syllabus. Thanks again for watching, and talk with you again soon.